So far as the defendant is concerned, well, no, because you can imagine the criminal court, it minimises having a distress for the witness, where the jury can have appropriate or inappropriate sympathy for the victim, which is not good for the defendant. And my professional experience is it does work, because it doesn't stop, in my experience, and I've seen juries will acquit, where I've trimmed the barrister's questions. So justice still works in the criminal courts. These tag questions, have a look. Many of you will never even have contemplated looking at the gateway. I understand there's going to probably be a civil gateway. So civil barristers can also be educated. But have a look at the criminal gateway. It's very interesting. Because, as I say, you can just simply say the defendant's barrister is puzzled. Say, well, just show the judge, don't show me. I don't think that's going to happen very often. So, give you two real-life examples in the limited time we've got. My client, SL, brain injured in a road traffic accident. He lacked capacity. There was, in my view, no question he lacked capacity. He didn't accept he lacked capacity, and we had all sorts of issues. So Master Leslie agreed with me before the trial that it would make life easier if we had a High Court judge who had a Court of Protection ticket as well as a Queen's Bench Division ticket to be able to deal with that. As it happens, he subsequently accepted the position, having met the deputy, liked the deputy, realising that it wasn't quite as problematic as he, and with his limited capacity, thought. But he got very tired. And I met him probably 6 months after his accident, so I've known him for some time. But we wanted the judge to get an impression, because I'd met him, and I could have a conference with my experts, many well-known experts that you would all know, and at the beginning he'd be fine, then he'd completely snap, then he'd get tired, and one of my experts would take him around for a walk and let's calm him down, and there was all this inconsistency in what he wanted to do, and he had these great ideas how he was going to buy all these apartments and do them all up, and that was his plan. Good plan, just he couldn't do it. So the judge, I went before the judge for the pre-trial review, and I got my solicitor to issue an application for the purpose of the pre-trial review, specifically dealing with the claimant giving evidence. That completely threw my opponent and his solicitor, because they had no idea what we were talking about. And that's not to be disrespectful of my opponent, very experienced barrister from London, and he even went to his head of chambers, a very experienced silk, saying, what's all this about? No idea, said the silk. Apparently, because this was reported back. When I spoke to him on the phone, because he rang me, saying, what's this all about? And I explained, he said, okay, understand now. The judge was switched on, because the judge agreed, because he got tired, the judge had read all the papers, we got a week in court, claimant will give evidence on the morning of day 2. But those of you who've been in the Royal Courts of Justice know that those courts in the wings on the first floor are very impressive. Makes you feel that's why you became a barrister. All the wood panels, pretty frightening though. Difficult. Witness box, definitely a crow's nest, no room for anybody else. And I said to the judge, we need to move court. Yes, I agree, says the judge. So we moved over to the far wings where the Court of Appeal sit, which is more of a modern court, it's brighter. And as the judge said, without me saying anything, he said, that will also enable his aunt, who was his litigation friend, to be able to sit nearby when he's giving evidence. Thank you, my lord, that's very helpful, because he'd read the stuff that I was suggesting. How do we facilitate? And that was very important. And the judge agreed to vet the questions. And the judge said at the pre-trial review to my opponent, do you have a problem with this? And he, having thought about it, said no. He was going to deal with the topics. But once the judge, there was no point in the judge doing it then, because the judge needed to read all the evidence to deal with the points of what other witnesses could deal with. And the judge was going to determine all that, probably at the end of day one, before the claimant gave evidence on day two. As it happened, I was literally about to stand up, and Kat and I were there. I kept saying the same figure, kept repeating the same figure. Eventually, they said I could have the figure with expletive deleted, but they paid me the appropriate figure, for which I ultimately needed the judge's approval. Why? Because he lacked capacity. But that was going to be very interesting, and I think if we got SL giving his evidence, the judge would have seen quite clearly the problems. Because one of the things the defendants, well-known experts, were saying, because he did have capacity. Well, then they said, well, he may have a capacity to manage some affairs, or maybe have a capacity with a trust, not a deputy. All this usual stuff that we as claimants lawyers see. And you'll hear a little bit more about that this afternoon when Lorraine Cavan and I are looking at that. But that's just, I can write some of these reports for them. Whether it's from Rehab Without Walls, with Neil and Kathy, I know exactly what their views are, constructive and positive, but I have to say there are others. I don't have the same experience. However, you'll hear more from Louise about this. This is the only case, GC's case, to date, in the civil jurisdiction where an intermediary has been used and given evidence. Intermediaries are now starting to become more common, but never actually got to the coalface. Now, poor old GC, again, he had an event in the cyclone not far away from here, being exposed to fumes. Again, strangely enough, and this is one of Steve Island's partners' cases, started it all off before it all moved around. I went out to see him. I was well trained by Michael Redfern many years ago. If you've got somebody who's badly injured, go and see them. You'll learn a lot more about him. And I went to see him within 6 months of this event. He wouldn't come out of the utility room. He was behaving very unusually, in an autistic type fashion. I mean, I'd never seen anything like it before, and as it happened, neither had any of the experts. The ultimate diagnosis was pseudo-dementia. He was obviously lacked capacity. But somehow, in the early stages, there was a statement from him dealing with the circumstances of the event. Breach of duty. We carried on with this case, and it was listed for trial January just gone, as you can see. Breach of duty with 3 defendants, 4 engineers, was in dispute until the 31st of December. The defendants then conceded in their openings respiratory symptoms, just leaving psychiatric. We agreed he was competent, because we had an interesting dynamic. We got his statement, which was dealing with the event, and we had other witnesses, but it would be helpful if we could have his statement in there. But equally, there was no question that he was going to have real difficulties if he ever gave evidence. So what did we do? Do we pull the plug on the statement, or let the defendants try and be smug and try and have a look at our witnesses rather than the claimant? So we decided, and we formed the view quite rightly, I think, that he was competent to give evidence. We instructed Louise Sheffield to say, well, we'll agree he's competent, but we think we need to have a registered intermediary. And Louise got involved for both parties, because they said, oh yes, we know Louise Sheffield, we're happy for her to get involved, and that's important for you all. The fact that Louise is not considered to be a hired gun for one side or the other, she's measured, balanced, and the judges will accept what she says. So, in the meanwhile, GC had moved to France. A lot calmer out there, he was still not well, but he was a lot calmer out there. Defendants, bless them, all of them, but tried to insist on him coming back to the UK to give evidence, still via an intermediary. The designated civil judge in Manchester, Judge Gore, said, he's fairly robust, but he said no. And we did it by video link from France, so Louise had a trip out to France as well. Now, there was Louise on screen. How do we do with it? Well, firstly, I took my wig and gown off. There were, of course, in court, was me, Winston Hunter, Michael Rawlinson, and several others. So you had a raft full of barristers, raft full of solicitors. Cat then was there as well. We're all booted and suited. And the judge. Pretty frightening stuff, really. So we decided, because I knew him, I would deal with this. And it's almost like saying, and I abbreviate GC, look at me, and it's almost look at me. And he trusted me, which was important. And one other barrister, leading counsel for one of the defendants, and the judge. Now, Mrs. Justice Shima Grubb, as it happens, had been a well-known criminal practitioner who had written a paper for the Bar Council all to do with vulnerable witnesses. So she was really up to speed as well, because I checked up on her when we found we were before her. Never, no disrespect to her, she'd probably never heard of me either, thinking, who is she? So she was up to speed. So we had everybody unrobed, all on the DVD. I had GC's wife come on screen to say hi, because she was in Manchester, just so he was reassured, and then she disappeared, and we had that. And I say to leading counsel for the defendant, do you need him to take the oath? Of course I do. I just knew what was going to happen. We started reading, or Louise started to help with the oath, and she'll tell you more. George then started to say that wasn't his writing, and it just went completely pear-shaped. So much so that my opponent then said, I've no questions to ask. And we achieved, I think in part, we weren't trying to cause GC distress. We thought it important for the judge to see it, because reading this, what was a diagnosis of pseudo-dementia on paper, particularly when the defendant psychiatrist was saying something different, and there was whilst they weren't alleging fraud and making it up, the defendants were unconvinced that he was as bad as he said he was. But you'll hear more about that. And what's very interesting in leading counsel for the defendant, but then in his closing submissions, because his junior thought that this was manufactured or facilitated by the claimant, this behaviour, at the time he was giving evidence, which I found rather surprising. We all looked a little puzzled, because he seemed to be the only one, but leading counsel adopted it, and the High Court judge said, well, that wasn't my impression. And in fact, her ladyship put a few sentences in to slap down counsel, and I flag it up for you, whichever side of the fence you're on. If something's an impression for the judge, be very careful how robust you are. And the barrister, who shall remain nameless, well known to Michael and myself, is an ex-medic, knows his stuff. But I have to say, in the course of that case, Kat and I did various case management conferences, and because my wife Janet there sends me out every time I go to court, I have tickets as well, and I have to explain that Janet's staff denies that she's Mrs. Grundy in real life, but will you buy a ticket? The only person that's ever refused to buy a £1 raffle ticket was this barrister. Even the defendant's solicitor bought some raffle tickets for Headway, so he perhaps reveals them, and he shall remain anonymous for the moment. My closing thoughts. This is an area that's familiar to criminal practitioners, but not to most of you, and hopefully you'll be a little more informed. I think it needs to change, and it will do. You have to change. You have to adapt now. Because if you don't, you become a dinosaur. Judges have got all the training. All judges, full-time and part-time, particularly sitting on serious sex cases, have all had training on vulnerable witnesses. And I've sat listening with all sorts of very good judges, crusty old judges, who know how it was and don't yet understand the manner of the delivery of evidence moving forwards. Now, 99% of them do. And that's very important. It's not a point scoring or catch out. It should be seen in a constructive fashion from both sides. And achieving best evidence, in my view, the point scoring and catch. If you're trying to catch someone out, that's not achieving best evidence. One example, years ago I did a clinical negligence case and I was cross-examining a nurse and I got this nurse to admit basically she'd made a mistake and got it wrong. So my opponent of course asked for 5 minutes and we sorted the case out, and I knew the judge pretty well, and before I was going he sent out a message he fancied a cup of coffee, so I went in and had a coffee with him, and he said, "You were lucky there, weren't you?" I said, "What do you mean?" The nurse agreed with me. He said, "Yeah, but that was because she was answering questions from you." She didn't necessarily mean that, which is very interesting. Just because someone on the judge's perception has made an admission doesn't mean the judge is going to follow down that route. So it's not a point scoring. And I think point scoring now flies in the face of the modern approach to the conduct of litigation and the presentation of such evidence. So I wish you all the best.